Peace to the gods, peace to the gods. Yusef here. Today got a little special presentment for you. I'm going to go over this document, Creditors and Their Bonds, with you. I'm going to read through this entire document, Creditors and Their Bonds, so that you can get a very good understanding of what this document is talking about. All right. So the first thing I'm going to do is I'm going to take you over to SPC University. This is the behind the scenes in SPC University. And right here you see I have what is called redemption books. But there's one in particular, this one right here is the one we're interested in. It's called Creditors and Their Bonds. So the first thing I want to do is I want to start out with some little maxims of law, because you really can't talk about law unless you talk about principles. The reason I like this document right here is it teaches you about the administrative process. You're going to get a thorough understanding of the administrative process, which is utilized in everything across the board, whether it's getting out of prison, discharging debt, whatever. It's some sort of administrative process that you're going to be using. Okay, so every effect has a cause. Every cause starts with a thought. Remedy starts by changing your thinking. The law of cause and effect. So notice that right out the gate, we are talking about the law of cause and effect, which is another name for karma. This is what I mean when I say that you cannot escape karma. They even understand this. This is why it's a voluntary system. They got to make sure that anything that happens to you, you are the cause of it through your own decisions and your own short-sightedness. Understand the first rule. This is why you have acceptance for value. You have to accept what happens to you because you are the one that brought it within your compass. You're the one that caused the problem in your life. Ain't nobody else's fault. Don't get mad at somebody you wrote, you didn't help me get out of jail and all that. You're the one that got yourself into the problem, and you're the one that has to get yourself out of the problem. A thing is unbound the way it is bound. A thing is unbound the way it is bound. Okay, so we're going to start off, and we're going to start off reading a couple of maxims and some principles, and we had to get that established first. So the first thing is we're going to talk about cause and effect. Every action generates a force of energy that returns to us in like kind. What we sow is what we reap. And when we choose actions that bring happiness and success to others, the fruit of our karma is happiness and success. The 7 Spiritual Laws of Success by Deepak Chopra. I don't know if you've heard of Deepak Chopra, but he's a very good spiritual teacher. And right here, he cites a universal principle of karma, of cause and effect. Whatever you put out, that's what you get back in. Those who live by the sword die by the sword. Judge not, lest ye be judged. The judgment you mete out will be meted out to you. There's a lot of ways of saying it. What goes around comes around, okay? I don't understand why people don't understand this principle. This is what they mean when they say fear the Lord. When they say fear the Lord, the word Lord is a synonym for the word law. Fear the law, because when you do something, understand that it's going to redound back to you. You got to watch. And this is why people will govern themselves accordingly. This is when you'll start to honor the creator of the balanced universe. Once you understand that any action or conduct that you engage in is going to redound back to you. If you engage in negativity, you're going to get negativity. If you engage in positivity, you're going to get positivity. All right, so let's get into this. All right, so right here we got karma. Here's another way of saying it. Okay, so let's look at this. The laws under which we live operate to our advantage. All conditions and experiences that come to us are for our benefit. We gain strength in proportion to the effort expended. Our happiness is best attained through a conscious cooperation with natural laws. This is also another reason why I'm always teaching natural laws. You have to study the natural laws first before you get into the man-made laws. The man-made laws are built upon natural laws. This is why you have to understand maxims and principles and things of that nature. The laws under which we live are designed solely for our advantage. These laws are immutable, and we cannot escape their operation. You can't escape karma. Only a fool, if you think you're going to do something and get away with it, you're a fool. There's no getting away with cheating on someone. There's no getting away with stealing candy out the store. There's no getting away with anything. The truth wheels out. The truth is going to come to the surface. the truth is going to come to the surface. The truth is going to come to the surface. Difficulties, disharmonies, and obstacles indicate that we are either refusing to give up what we no longer need or refusing to accept what we require. All conditions and experiences that come to us do so for our benefit. Difficulties and obstacles will continue to come until we absorb their wisdom and gather from them the essentials of further growth. Sorry about that. Difficulties and obstacles will continue to come until we absorb their wisdom and gather from them the essentials of further growth. That we reap what we sow is mathematically exact. We gain permanent strength exactly to the extent of the effort required to overcome difficulties, the Delphin system transforming the way the world thinks. Okay, so effort is deliberate exertion of physical or mental power. Effort. The most laborious activity that you can engage in life is thinking. Constructive thinking, not just lackadaisical thinking, constructive thinking, and thinking with an intent and a purpose. If one exercise that you can try to do is to sit in front of a candle and stare at it and keep one image in your mind for 60 seconds without allowing another image to invade your mind. See if you can do that. Commit thy works unto the Lord, and thy thoughts shall be established. Notice that they use the word Lord right here. This is what I mean when we do comparative religious study. What is that word Lord, a synonym for it? It's the law. Commit your works to the law. And once you understand how the laws operate, remember earlier it says the laws are immutable and they work with exactitude precisely the exact same way every time. Well, that's where you can get some faith now. You can put some confidence. You can eliminate worry once you understand how the laws operate. This is why it's important to understand natural laws, because natural laws have never changed. They've always been the exact same since the beginning of creation, and they will be the exact same until the end of creation. They don't deviate. They don't change. Not a respecter of persons. This is where the playing field becomes equal. You cannot fight these people on a playing field that is of their own design. If you're going to fight these people, you got to fight them on a playing field that is going to equalize everything, and that is what the natural laws are. All the creators of balanced universe is just letting y'all suffer because until y'all say y'all want to return back to them. You say, okay, you want to do it on your own. Okay, go ahead. Let's see how successful you are. So the next one, it says, the Lord of hosts has sworn, saying, surely I have thought, so shall it come to pass, and I have purposed, so shall it stand. Isaiah 14:24. Thoughts have become things. Where a man ways please the Lord, he maketh even his enemies to be at peace with him. Proverbs 16:7. If God is with you, who can be against you? If you please God, everything you will not. If you bring yourself in, pleasing God means to bring yourself into harmony with God's laws. All right. Be not deceived. God is not mocked. For whatever a man soweth, that shall he also reap. This is very important. A lot of you people trying to get out of prison, you think you're going to mock God. You think you're going to find a loophole. You think you're going to find some way to get out instead of repent. Nothing's going to change for you until you repent. Repent means that you have to turn away from your ways, your way of thinking, your way of life. If you continue down the same road that you've always been on, you will always continue to get the same thing. If you want to have change, you have to be the change that you're seeking. Let's look at what this Cherokee Native American says. This segues right into what I'm going to talk about right now. An elder Cherokee Native American was teaching his grandchildren about life. He said to them, a fight is going on inside me. It is a terrible fight, and it is between two wolves. One wolf represents fear, anger, envy, sorrow, regret, greed, arrogance, self-pity, guilt, resentment, inferiority, lies, false pride, superiority, and ego. The other stands for joy, peace, love, hope, sharing, serenity, humility, kindness, benevolence, friendship, empathy, generosity, truth, compassion, and faith. The same fight is going on inside you and inside every other person too. They thought about it for a minute, and the one child asked his grandfather, which wolf will win? The old Cherokee simply replied, the one you feed. So let's go on. I said, why do I have an exemption? Now, an exemption is the phrase that we used in the old school to show that you could discharge debt. You are exempt from having to pay for anything. An exemption in the old school was represented by your social security number without dashes. That represents a closed account. The social security number is an account number. So when you see it with dashes, that represents that it's open, which means that you are debiting and crediting that account. When you take the dashes away, that represents that it is closed, but it remains open for adjustment and set off, which is what we're going to be using it for. Okay, the social security number is the number that represents the artificial person straw man that is considered to be a transmitting utility. The reason it's called a transmitting utility because it is the bridge between the private and the public. Okay, the private is where the substance is. The private is where the value is. There is no value in the public because the public is bankrupt. Okay, so this is why they request your signature on everything, because your signature represents future labor. Okay, future labor, which is the only thing that they can have stock in because they are bankrupt entities. All right, labor is very valuable. Labor is very valuable. Okay. So it goes on, it says, you have an exemption because you have no money. There's a constitutional prohibition against paper money. A country, a state, has to have a name, people, boundaries, and money. If one of those elements is missing, there is no country. Okay, so this is why we're operating under a corporation, because the United States don't have no gold and silver. All right, so there really isn't a republic per se. All right, we're operating in this corporate democracy. Okay, if Connecticut has no people, it is not a state. If it has no geographic boundaries, it is not a state. If it has no money, it is not a state. Look at the cause and effect. Why is there no money in circulation? The reason there's no money in circulation is because of 1933. Money is gold and silver. We have to understand what money is. Constitutionally mandated money for payment of debts is gold and silver, which is called money of exchange. So there's no money per se, quote unquote, in circulation. We do have a medium of exchange, what people call money, which is called Federal Reserve notes. So why is there, it says, who had authority to demand the money to be given to the Federal Reserve banks by May 1st, 1933? Who had that authority? Did the people, were we responsible for that? No, we weren't, if we were in our private capacity, but that's what they did. They came up with the idea to change your status to that of a dependent. Once you became a dependent, the doctrine of parens patria would step in, and now they had jurisdiction over you, or what is called in personam jurisdiction over your person. And now they replaced, because no private person was required to give gold and silver to the government. They didn't have any authority to request that from private citizens, only people in the public, which are government employees. But because the public had been sufficiently dumbed down, and which they had been working on for the last 30 years, as my research shows me, they reached the point of capitulation where they knew in 1933 they could fool everybody and have them turn in their gold. The first thing was they had to get everybody out of the country, because in the early 1900s, the majority of people lived in the country. There weren't all these cities like where they are now. I saw an old picture of Atlanta, Georgia in 1900. It wasn't nothing but a little small blip on the map, and most of Atlanta, Georgia was a peach field. That's why the main street in Georgia is Peachtree Avenue, because it was a peach tree. It wasn't nothing. And the federal prison that they built here, Atlanta Federal P, which is one of the oldest prisons in the country, they had prisoners build it. They had on the stripe let me see if they got a picture of this, as I can show it to y'all. You see if they got any images of it. Okay, this is some of the old, Atlanta Federal Prison. This is Atlanta Federal Prison. Prisoners built that. And I was actually in the warden's office, and he had pictures. They actually had photos of the prisoners building the prison. That's where Al Capone was in. And they had balls and chains with the stripes, man. I couldn't believe it. Like they had on the cartoons. That was actually real. They had prisoners. They built their own prison, and they had ball and chain on their legs. Let me see if I can. I couldn't tell. That's Alcatraz right there. They had a ball and chain on their leg. It looks Atlanta Prison Farm. That's the farm right there. I don't see any print, but it's, oh yeah, there you go right there. See that right there? See, at 158 Atlanta Penitentiary photos and premium. That looked like it right there. That's how it looked, you know, back then in the day. They had stuff like that on. That's how they looked. They'd have a ball and chain on, and they actually were building the prison. So, you know, understand that, you know, get some history. Stay out of prison, man. Prison is, let me tell you, the only thing worse in prison is probably death. There's they gave them balls and some, I don't know where that is. They still giving them stripes right there. That's how old that stuff is, but they still do that in some places, give them those stripes. But they would have a ball and chain on their ankle, man. You had to carry that ball and chain. You couldn't run with that ball and chain on. So let's get back. I didn't want to digress too much, but I thought that'd be interesting. Okay, so there isn't any money. Okay, they took the money out of circulation. Okay, the money is in a trust for the people in the state. It's called a constructive trust, necessary when fraud is involved, no unjust enrichment. So this trust that y'all keep talking about, do you understand it is a constructive trust, which is not actually a trust? A constructive trust is a legal fiction entity, okay? A definition of a legal fiction is an assumption something is true, even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates. Constructive trusts are created to avoid unjust enrichment, okay? So when they took the gold, naturally there was some expectation of the return of that gold. See, they couldn't just take our gold and not give us anything in return. There had to be some expectation that, okay, we're giving you the gold for safekeeping so you can use it, but you're not just taking our gold and not giving us any. Think about that for a second. You think your federal government can just take your gold and give you nothing in return? Well, what they try to say is that they gave you Federal Reserve notes, and this is when you get into Perry versus the United States. So let's go back. So now it's a trust that is formed. Now this is why it's good to study the concept of trust as well. A trust is a right solely enforceable in equity. So right here you see this little diagram that they have on here, and what they're showing is they're showing the private and the public. On this side of this little line is the private. There's substance over here. There are people, but there isn't any gold and silver. And then on the public side there's fiction, persons, and paper money. Okay, so all this was, the gold was put in a trust, which is the trust corpus. So the title to the gold, title to the land, title to anything that you can see. You don't have title to anything anymore. That's why they give you a certificate of title. All that is in trust. The trustee is the Secretary of the Treasury. And how did I come to that conclusion? By reading the Federal Reserve Act. That's who you find the players in the Federal Reserve Act. And John Henry Doe is the beneficiary. John Henry Doe, the beneficiary, is not you. Y'all keep saying you're the beneficiary. The beneficiary in the public is an all caps name. That is a legal fiction entity. Okay, it's not you. And that's where a lot of you become confused. I'm the beneficiary. You are a representative of the authorized representative of the beneficiary, the all caps name. Okay, so your application for registration, you register yourself and it goes into a trust corpus. So now, once again, we're looking at public and private. Okay, on the private side, we have possession of substance. There's dirt, houses, shoes, jewelry, coins, bread, but there isn't any money, labor, and life. And on the public side, you have possession of fiction paper, legal descriptions, receipts, certificates, receipts, and Federal Reserve notes. There's no labor and no life on the public side. So this is a private and public concept that you're being shown right here. Okay, so let's look at some of the rules. You cannot pay. He who has the gold pays the bills. Trustees pay bills. Okay, you cannot pay, so you need to stay away from that word pay because there's no gold and silver. Gold and silver, you don't have any gold and silver to pay anything with. That's the only thing you can pay something with is gold and silver. It goes on, you're exempt. He who demands payment knows or should know there isn't any money. You have to be exempt. They took all the money. If they took all the money, how are they going to expect you to pay something with money? You are not expected to pay. You loaned all your substance to the fiction by application and registration. You have nothing but possession. You have no titles to substance. You only have title to your rights. Everything is prepaid. Everything is prepaid because there isn't any money.
All right, they took the gold and silver. They owe us. This is what makes you the creditor, because they owe the gold and silver back to you. So this is why you have the status of creditor. You have the status of creditor because they owe you. We gave them something, but there is an expectation of the return of that gold. So that's why we would tell them, we say, okay, the day that y'all return gold back, I'll pay you. But in the meantime, I'm going to give you this negotiable instrument as an offset to the public obligation, and then you can do an accounting procedure and zero out this account. You have to do a set off because there ain't any money, so you have to use something of value to offset something that has an obligation of an equal amount. It has to be exact same amount. You can't have different amounts. You're not going to get any change. So if there's a public debt of $300, you have to do a private negotiable instrument for $300 for there to be an offset or a set off. You can't have they say you owe $300 and then you write something for $305 thinking that you're going to get some change. It's not happening. Listen real closely. How are you the debtor and creditor simultaneously? Well, you're really not the debtor and creditor simultaneously. The debtor is your straw man, your all caps name. The creditor is the Christian appellation of your name. Okay, now, you're simultaneously a creditor and a debtor because your straw man is a debtor and he owes you money because they owe the gold back to you. However, your straw man has incurred an obligation, like you've got him in a contract with a mortgage, a car note, or something like that. So he has a duty to perform on an obligation. Okay, so you as a private person who have all the substance, you can tender a negotiable instrument to offset that obligation. Okay, so that's how you're the creditor and the debt. The straw man is the debtor. You're the creditor. However, you are the surety for the straw man. When you read your secured party paperwork, in that paperwork you outline how you will accept all presentments and you will satisfy those presentments. That is what it means, acceptance for honor. Let's look at the word acceptance for honor. It's called, there is no word acceptance for value in legal terms, but there is a word acceptance for honor. Let's look at this word. It's an important word for you to know. What is an acceptance for honor? Acceptance for honor. Right here, acceptance for honor. All right, what is that? Acceptance for honor. All right, so acceptance for honor. An acceptance or undertaking not by a party to the instrument, but by a third party for the purpose of protecting the honor or credit of one of the parties, by which the third party agrees to pay the debt when it becomes due if the original drawee does not. This type of acceptance inures to the benefit of all successors to the party for whose benefit it is made. Also termed acceptance super protest, acceptance for honor. Okay, and this is what you're doing. You're doing an acceptance for honor. All right, because you are not the debtor. Your strawman is, you're a third party to the transaction because both of the debtor and the creditor in the public are legal fiction entities, okay? All right, the state is the corporation that says you owe some money, that's a legal fiction entity. Legal fiction entities can only engage with other legal fiction entities, okay? The reason for that is, it's a very simple test. If you're on here and you think that what I'm saying is not true, you have a right to face your accuser, okay? They put that in the Constitution for a reason. So when you're in court and you ask them who has the claim against me, and they say the state of Georgia or the state of California or the state of New York or the state of Florida or the state of Texas or the state of Virginia or the state of Tennessee or the state of Oklahoma or the state of Montana or the state of Oregon or whatever, okay, you simply repeat, okay, well, I call the state of whatever to the witness stand because I do have a right to face my accuser, because these people like to play the game as if legal fiction entities have some sort of tangible existence. Okay, they don't have a tangible existence. Okay, they live in, they are constructs of the mind. Okay, and that all caps name is a construct of the mind. They call it a person. A person. We have a word, acceptance for honor. I want you to incorporate that in your vocabulary, okay? All right, so your exemption. Okay, an exemption is freedom from duty, liability, or other requirements, Black's Law 7th edition. Now, here's the next one I want you to pay attention to because it's going to come up a lot, and this is the word mistake. The word mistake is something you need to be aware of because this is why you have to give people in the public grace. Okay, because if you tender to them a negotiable instrument and they don't set it off right off the bat, or you do something in court and they don't accept it right off, you always have to presume they made a mistake. You always have to presume they made a mistake. It is very, very effective. You must have made a mistake. There must be some misunderstanding. You have to take that position. You can't start launching, oh, you're committing fraud against me, and you can't do that. They may actually have really made a mistake. Okay? You have to give them the benefit of a doubt. So because the mistake is under the laws and it's under the UCC. So we're going to read it. Okay, mistake equal cause. Okay, Black's Law, fourth edition. Some unintentional act, omission, or error arising from ignorance, surprise, imposition, or misplaced confidence. A mistake exists when a person, under some erroneous conviction of law or fact, does or omits to do some act which, but for the erroneous conviction, he would not have done or omitted. It may arise either from unconsciousness, ignorance, forgetfulness, imposition, or misplaced confidence. And you'll see this in UCC 1-103. Right here, when you look at creditors and their bonds and you see this ARS, this stands for Arizona Revised Statutes. Arizona. So most of the codes in here are coming out of Arizona. You have to find them in your particular jurisdiction. So in Georgia, this wouldn't be 47-1103. It would be OCGA 11-1-103. That 1103 is going to be in all states. In California, it's going to be California Civil Code 1103. That 1103 is always going to be there, but the convention they use to describe it is going to be different in each jurisdiction. But it's always going to have that 1103 attached to it in some shape, form, or fashion. So always remember that. So right now, you have this right here is UCC 1-103. So right here, 1103, unless displaced by the particular provisions of this act, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause shall supplement its provisions. So these supplement the provisions, okay? Understand that mistake is part of the game. All right. So we're going to this is very important for you to remember because it's going to come up later in class. We're going to have a discussion once we start doing our administrative process. This is actually going to be incorporated in your correspondence to the public officials. All right. In another way, though, but you're going to see it. So right now, you need to listen to the lecture and impress this upon your mind. Mistake is necessary, because it's a big part or component of your administrative process, a presumption that they made a mistake. Okay, now, can I get in trouble using a bill of exchange? It's people always wonder, can I get in trouble? Yes, you can if you put routing numbers on it. So let's go. It says, you can get into trouble crossing the street. There are rules for crossing the street and rules for using bills of exchange. Bill of exchange, an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to order or buyer, sometimes called a trade acceptance. So right here, a bill of exchange is a three-party instrument. That's the easiest way to remember it. A bill of exchange is a three-party instrument, and a promissory note is a two-party instrument. A promissory note has a maker, okay, and a bill of exchange has a drawer, okay? Drawer and maker. Okay, the difference is when you're a three-party instrument, there's a third party involved. So you have the person who writes the check, the person who receives the check, and then the place where you take it to go get it cashed. Okay, but with a promissory note, there's only a two-party instrument. There's no place to take it to go cash. All right, it's just based off of your ability to honor your obligations. This is why a lot of people don't take promissory notes, and a reason why a lot of promissory notes are ineffective in this particular procedures that we're using. With this right here, you're setting up an account, for lack of a better word, with the Treasury Department by tendering your bond to them and them retaining it, which constitutes a deposit, and then you're going to reference that deposit every time you create some sort of negotiable instrument and attempt to discharge some debt. Okay, so understand the distinctions between a bill of exchange and a promissory note. It would be wise for you. I don't know if people are going to do it, but it would be wise for you to go to SBC University and did I got American jurisprudence up here? Let me see if I got bills and notes in here.
That's corporate jury. Yep, there it is right here, bills and notes.
This is the document this book that you study. This is what I studied. I studied this when I was locked up, okay? And I'm giving you the same things I do. This is negotiable instruments. It's called bills and notes because we're talking about bills of exchange and promissory notes. Bills of exchange and promissory notes. So it's called bills and notes. So this is going to give you the case law, where you're going to study the principles behind negotiable instruments. That's what you're going to master. You're not reading this to study law. You're reading this to ferret out the principles that are and how they are applied in different situations as it relates to negotiable instruments. And this is why these are very good for you to read. You should become acquainted with reading case law. That is going to set you apart from everybody. You're never going to be set apart from anybody walking around following gurus, writing down some shit that somebody else told you. You're never going to be nothing. You're just going to be just an average person just spending money and somebody taking your money from you. That's all you're going to be. You got to start reading these law books. It's not hard. I know at first it may be a little intimidating. It was intimidating to me. But once you kind of learn some basic things, you'll see it's very, very simple. You know, once you get past that fear, it's just like swimming. You know, when I swam, before I learned how to swim, you know, I was, I remember the day I learned how to swim was the lifeguards. They took me into the deep side of the pool and on the low diving board, maybe jump into the water. And there was a lifeguard in there waiting for me. And when I jumped in, I was frailing and scared to death. And then when he pulled me over to the side, I was like, man, that wasn't really nothing, man. You know what I'm saying? Why was I doing all that shit and afraid? And that same day, I was jumping off of the tower. That's how fast I made the transition in swimming. Once I got over my fear, I was on the top board jumping, doing cannonballs off the top board and everything the same day. Okay, and that's how this is. Okay, once you get understand that this ain't nothing to swimming and everything, you're gonna be doing the cannonballs off the board. Yeah, man, this shit is easy. It's easy to read a citation of authority. All this shit is easy. I thought this shit was complex. It's not complex. But what makes it easy is when you study words. It's a word game. It's a language that you have to learn. It's never going to become easy for you if you don't stop and look up every word you don't know the definition of. Let me stop and say, if you have not incorporated into your study habits the habit of never passing a word you don't know the definition of. If your intuition tells you, I need to look up this word, you need to do it, because sometimes you may think you know the definition of the word, but words used in the legal arena are different than the one used in everyday parlance. You cannot expect these words to mean the same, okay? So you have to take time. The first couple of weeks, 6 weeks, I devoted just looking up words. I didn't even read. I read these documents, but I would just get a Black's Law Dictionary, and I would just go through the Black's Law Dictionary, just read it. And it's very interesting just to look in the dictionary and just read words. Just to sit down and just look at words, you know. You know, if you like to get high, just get high and go just open a Black's Law Dictionary and just read some words. Just, you know, you'll trip you out. You'll be getting taken on the joint like, man, this is interesting. This shit is interesting. Damn. It's a very interesting book. Legal dictionaries are very interesting books. They're very interesting books. Everybody should have one on their in their library at home. And right here, you can see right here, bills and notes is the various forms or contracts. Right there off the rip, it tells you what a bill of exchange is. A bill of exchange is a contract. These are private negotiable instruments. They're on the private side and may be negotiable or non-negotiable. Bills and notes are commonly defined as commercial paper or negotiable or non-negotiable instruments. And in turn, commercial paper is commonly defined as negotiable instruments, drafts, checks, certificates of deposits, and promissory notes. Commercial paper is governed by the provisions of Article 3 of the Uniform Commercial Code. And right here, you know, this is very interesting. You start reading this, and this is where you get your foundational education. This is where you start your research with a legal encyclopedia. When you want to know a subject, you go to the legal encyclopedia. Like, you know, like people would say, oh, it's de facto and de jure. I went to American jurisprudence and studied de facto, and it got a whole different concept than what the people were telling me. They say it's a de facto government. Well, de facto governments are lawful forms of government. And mean it's an unlawful form of government? People walk around, it's an unlawful form of government. De facto is not unlawful. It just means the citizens have acquiesced to that form of government. And anything acquiesced in that is approved by the population, it becomes legitimate. So, y'all need it. That's where you study these subjects. Stop going to gurus. Go in here and study it. Study the subject. Study the subjects here. You start here. And the reason why you start here is because they're going to give you citations like these numbers at the end. Okay, they come down here, and then you can look at this right here. It says 16 as to consideration generally, see subsection 141, and it tells you some case law that you can read to expand on it, like footnote 17. What is footnote 17 right here? Non-negotiable instruments are governed by the rules of law applicable to ordinary contracts. Okay, so that's 17. So if you want to get a judge to explain it to you, this is the case it's telling you to read. Go read Edgar versus Haynes, and that's going to give you some education on how negotiable instruments are contracts. Do you start to see how you can utilize this to become an expert on a subject? The judges are the ones who have been given the duty to interpret the law. That's who you learn from, not from the guru down the street. Learn from the people who've been given the duty to interpret the law. All right, so let's continue. All right, so we're on creditors and their bonds. Okay, so a trade acceptance, a draft or bill of exchange drawn by the seller on the purchaser of goods sold and accepted by the purchaser. Once again, a bill of exchange is another word for it is a trade acceptance. A negotiable instrument, UCC 1-104E, you need to know what makes an instrument negotiable. There's actually case law where the judges said it has to have paid to the order of and all those things on it. An instrument is a note if it is a promise, and it is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person is entitled to enforce that instrument, may treat it as either. Do you know what negotiable instrument falls within that category as both a note and a draft? The promissory note that you sign with your mortgage. What is a letter of credit? A credit instrument issued by a bank. This is the Christian appellation, John. You're issuing the credit instrument. You are the issuer, drawer, maker of the instrument. You're the issuer, drawer, and maker. You always are. Anytime you sign your name on something, you are automatically the issuer, drawer, or maker of that instrument. Always remember that. Okay? So it's a credit instrument because there isn't any money. You're signing your name on something. It's a credit instrument guaranteeing payment on behalf of its customer. The all caps name, okay, you're the surety for the all caps name. You're loaning him your signature to guarantee the repayment of something in a future date because there isn't any money. We're only using credit instruments. So people use this word pay, but you didn't actually pay for anything because you didn't give them anything of substance. You gave them a credit instrument. A promissory note is just what it says, a promise to pay. That right there necessarily means that there's some future event in the future. But sometimes to the bank customer, John, for a stated period of time and when certain conditions are met. Letters substituting the bank's John credit for credit of another party, blah, blah, blah. Bank, what is a bank? An institution usually incorporated with power to issue its promissory notes intended to circulate as money, known as bank notes or Federal Reserve notes. You are also a banker, a private banker, and you're going to issue your own script as well. Banking, the business of receiving money, charges. A charge is money on deposit, loaning money, notes, discounting notes, 100% discount, issuing notes for circulation, promissory notes, collecting money, exemption on notes deposited, ACR 192, and negotiating bills of acceptance, blah, blah, blah. All right. Now, here are the rules right here. These are the rules to the negotiable instrument. I want you to listen to these very carefully. Okay. Here's the written rules. It must be unconditional. It must be in order. This is a bill of exchange we're talking about. It must be in writing. It must be addressed to another. It must be signed. It must order payment of a sum certain in money. And here are the unwritten rules. You must have the authority to sign it. You must have assets sufficient to back it. In our case, the asset sufficient to back it is your labor. Okay, it must be dated. It must be a dollar for dollar, some certain exchange. It must apply to an existing public debt. You can't use negotiable instruments on private debts. People come to me, can I pay you, Yusef? No, It must be non-cash item. It is not collectible. It is prepaid. It is an accrual item, always a zero balance, double entry bookkeeping. It must have a letter of credit to go with it. Know how to go all the way, just like crossing the street. Okay? And that's another thing we used to say. Don't start any process if you're not willing to go all the way all the way on. If you're not willing to go all the way to court and fight all the way in court, don't start the process. So right here, parties of the UCC1 form debtor, the all caps name, must have name, address, and designate organization or individual, and sometimes have a number. Secure party is your lowercase, you, the Christian appellation of your name. All right? Now it says in Illinois, both parties must be in all caps, all right? Form must designate collateral and establish a value, but not necessarily a sum certain. The form must be supported by a security agreement of some sort. That's a UCC1. You have been signing for the debtor since it was created. When you sign for the debtor, you are wearing an authorized representative hat. Can a man be a secured party on a UCC1 without being a fiction? Some say yes and some say no. It is not the form that is the controlling document. It is the security agreement. That's true, because the UCC1 is just a notice. It's a security agreement that's the controlling document. You just put that notice out to let people know that you have a security interest in property, and if they need to know the details of that, that's why you have your contact information on there. They can contact you and ask you about it. You don't file all your additional paperwork with. You don't sit there and file pictures of gold with it. You don't sit there and file your security agreement with it and your bond and your copy of your birth certificate and all. You don't file all that shit with a UCC1. You just file just the UCC1. All that extra extraneous shit that you put in the public for other people to see is unnecessary. All right, so let's continue. You can't contract with yourself as a maxim of law, but you can sign the security agreement in different capacities, one being the trustee of the debtor, trust, and the other being you. This could be considered to be self-dealing, but can be overcome as there are no contravailing equities that could serve equally to fulfill the intent and balance the respective obligations. The security agreement should identify at least some of the collateral specifically. Do not argue with filing officers. There are 6 UCC filing regions. You may file in any state in the region where you want to do the filing. So if you're having a problem filing in your region, you can file in another region. I always tell people, though, just list the debtor as a trust. Just put because really the real reason you're filing the UCC1 is so you can have a commercial chamber where you can track your transactions. That's why it's like a bank account that you're opening. So you're really not don't overly concern yourself with if, I got the debtor's name on there. Just put John Henry Doe trustee or trust. Okay, let them know this is the name of the trust and you have a security interest in this trust, and just hand it to them like that. Only thing you're interested in is getting a UCC filing number. You need that filing number. Okay, so don't get caught up with the all caps name that's on the UCC1 form. It's not going to be relevant in the long term. It's not relevant in the long term. Okay, so let's go. John can be owed money by the debtor even if the debtor is unable to pay. John is substance. The debtor is a fiction. The registry at the Secretary of State is both the republic and in the nation. The debtor has no means to pay John even if the debtor receives public payment for work that John does on behalf of the debtor for the employer. The reason he's not receiving any payment is because Federal Reserve notes can never be payment because they're promises to pay. How can a promise to pay be a form of payment? Think about how these people are trying to get you to think. Think about how they're trying to get you to think, and you need to adjust your thinking because you've been programmed. Every service John has supplied to the debtor since John's birth has been done without payment, but not without expectation of payment. There's an expectation of payment in the future. That's what makes you the creditor, because they owe you. They've been paying. You've been working on your job all this time thinking you've been getting paid, and you haven't been getting paid. They've been giving you promissory notes of promises of payment. Okay. So the debtor's failure to pay John has resulted in an account payable in favor of John, which is you, the all caps name, your 1041 form, lien form. Cause John's taxable activities, effect tax return is due. Cause John supplied labor and has not been paid, effect there's a deduction for accounts payable. By filing the public form in the public registry, John could be considered to be a fiction also. But if there is no other way to give public notice of the debt that is owed to John, this is the choice out of necessity. Because you have a lot of people say, you're using their stuff when you file a UCC1. Well, that's the commercial registry for doing what we've done, and it's out of necessity. It's a doctrine of necessity that that is in this. It says, filing the UCC1 equivalent form in France would not make a German creditor a Frenchman. It would just be put the claim into the jurisdiction of France. UCC1s give public notice that the secured party has a commercial claim, but not that it is in commerce. Absolutely. Now let's look at loans. Are all loans fraud? This word fraud is one I want to get people to stop using so much. A lot of people in this movement love to use the word fraud. Fraud is one of the most difficult things to prove in law because you have to prove intent. So let's stay away from fraud, an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right, a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceived and is intended to deceive another so that he shall act upon it to his legal injury. Beautifully worded. So that's fraud, your definition of fraud out of Black's Law 4th. Lend, to put out to hire or compensation, Black's 4th. So, are all loans fraud? The answer depends on where you're going to make your stand. If you're going to use the acceptance method of settlement, no, there is no fraud. It is just business in a system that has no money. If you're going to use a conditional acceptance and dispute the procedure, there may be fraud. The procedural discovery will expose the wrongdoing without having to charge fraud. And if you're going to straight out dispute the debt, you'll have to claim fraud. Fraud involves intent, which is difficult to prove. The one who claims the presence of fraud bears the burden of proof. The burden of proof is on he who asserts, not he who denies. All right, so I'm going to end right here. We're going to take up tomorrow, same time, same place. We're going to the acceptance method. Be here at 10 o'clock tomorrow. I'm doing these late nights. I ain't gonna do them real long. I'm going an hour and a half tonight. I'm not going to be on here all night long teaching and teaching and teaching. But we're going to take this day by day, step by step. All right. So with that being said, I want to thank everybody for coming out tonight. I will see y'all tomorrow at the same time, 10 p.m. Eastern Standard Time. And we're going to continue studying this document, Creditors and Their Bonds. And hopefully you can get something from this that will help you in whatever situation that you're in. This is a very, very good document. I still, as to this day, haven't seen anything better than it. Just if you y'all need to read this. You may not understand everything at first. The reason you don't understand something at first is because your mind hasn't created brain cells that are receptive to the information, and that requires repetition. That's why you got to read it again, and then that's how you have an aha moment. Because once your brain creates the necessary brain cells for the reception that are receptive to the information, then you get understanding, and that's your aha moment. And that's only achieved through repetition. Unless you're a genius and the first time you hear something, you just understand it, like me. But anyway, we are going to be back tomorrow, same time. Get this out the way. I'm always got this in my face. We're going to be back tomorrow at the same time. Be here. Bring your pen and paper. We're teaching class, SPC University. I'm Yusef.